Thank you, Beate and myself. And now we proceed to the United Kingdom. So Andrew, please. You don't have slides for this either. Okay, please.
Thank you. Yes, English company law given second billing after Nordic company law. Well, I wondered why that was, and thinking about it, it's because English company law bears primary responsibility for the shareholder-centric focus of company law. Now, company lawyers in the UK will confirm that this was a historically contingent thing. This emerged out of partnership, and when the separate legal entity came along, we just kind of tacked it into partnership, and the partners remain central. So the shareholder-centric focus of English company law is historically contingent. And the spread of this around the world is also historically contingent, based on England and the UK's colonial past, where we exported our law and imported a lot of other good things. So that's English company law, and that's why maybe Beate put it directly after the Nordic model. Now, let's talk about realism. Nordic countries may be the first movers. The UK will be the last movers. The UK, company law reform in the UK is completely hamstrung by neoliberal ideology. If you look back at the 2006 company law reforms, you will see there is absolutely no prospect of the UK changing from a shareholder-centric model. And so I think there's three main reasons. The first is neoliberal ideology. Top company law scholars in the UK say that it is axiomatic that it is a absolute truth, an unchallengeable truth, a fact of nature that shareholder primacy equals the common good. So when we, as lawyers, deal with axioms, this is what neoclassical economists deal with. We as lawyers say, where did you find this axiom? How did you discover it? Did you dig it up? Did you use some kind of scientific technique? No, we just know it to be true, and this is the basis on which we will proceed. This is not really open to question in the UK, and the idea that companies should be run for shareholder primacy, this quasi-legal social norm that we discuss, is not in our law, but it is not to be challenged, and our law must accommodate this because this shareholder primacy is an objective truth. So that's a problem. Secondly, you can discover that from the company law reform that politicians are very keen that English company law should remain competitive. That is, we don't have many exports anymore, but we do have company law, and we continue to export it around the world. Germans, Austrians, Danes, etc. flock to our shores to use our light touch regulatory regime. So we facilitate you doing business at low cost. And the third reason why we won't change company law is because we are obsessed with share prices. Not only because we know that share prices reflect social wealth, but also because our entire economy now depends on share prices remaining high. You only need to look at the action of the central banks over the last 3 or 4 years, pursuing unconventional monetary policy, purely with the goal of reflating the stock market, purely in the hope that some of the beneficiaries might start spending again on stuff that they don't need. Everything will then be okay. So this little dose of realism before I come on to my reform proposals, if change is going to come to the UK, it has to come from the EU. That's the only way the UK is going to change, and if the EU pushes too hard, we might leave. Then we'll be an offshore corporate law haven, and you'll then have to put up barriers to your citizens coming and incorporating under our law. Please do. You can see what would happen, right? The EU regulated banks' ability to pay its executives enormous bonuses. The UK is the country which was the closest to being destroyed economically by its banks of all the member states of the EU. What was the response of our politicians? It was immediately to launch a legal challenge to the directive requiring executive pay to be capped, even though the social costs of that practice amounted to around about 20% of GDP. This is an enormous externality. If I carried out an economic activity that cost 20% of GDP in externalities, I would be stopped. Banks could not be. Okay, so this is a kind of a preface to my reform proposals and a dose of realism in case you think they sound good and they might happen. Okay, Section 172 of the Companies Act, we're probably going to hear more about this over the next couple of days. Many of you know it says companies should be run for the benefit of their members as a whole, but taking account of a range of stakeholder interests. Sustainability is not in that list. I don't think it matters because it's still open to directors to consider sustainability because the list is non-exhaustive. But as I said in the previous presentation based on our joint paper, the limits of this have not been explored, right? This basically says you can pursue any stakeholder interest where you can make a plausible argument that doing so is capable of producing returns for the shareholders. But the limits of this have never been explored. Litigation is non-existent because directors simply don't use the discretion because of shareholder primacy. What about beyond the business case? Now, this is very rarely discussed. When I read corporate social responsibility literature, it's all win-win, business case, doing well by doing good. I don't think most sustainability initiatives have a business case. I don't think you sell more products because some aspect of your remote supply chain took account of sustainability. I think it's very hard to make business case arguments. So I'm really interested in the idea that we go beyond business case. Company law has to go beyond the business case. I don't know whether English company law, in reality, with a wide business judgment rule, with Section 172, would contemplate a kind of gradual expansion of how we frame the business case. That's something that hopefully we'll see one day. So in terms of more far-reaching reform proposals that I would like to see a duty on company directors to identify and internalize their externalities, both where there's a business case for doing so, which we might say they sometimes do now, but even where there is no business case for doing so. And I think this can be argued for both on the grounds of environmental sustainability, but it also can be justified, defended on the basis of a very standard economic argument. If you read Ronald Coase, you can use Coasean economics to defend the internalization of externalities through corporate governance. Of course, this is anathema to anyone who believes that shareholder value is axiomatically the public good. But that's what I'd like to see happen. I note the European Commission's recent communication on corporate social responsibility. They want companies to disclose and take account of their impacts on human rights, on the environment, and so on. They've expanded Ruggie beyond human rights to encompass the kinds of issues that we're concerned with here today. But what is missing from that statement is any idea of whether this goes beyond the business case. It entirely ignores that question. We need clarification. Does the Commission want companies to go beyond business case scenarios in internalising their impacts? We need clarification of that. Now, if we are then going to see the possibilities which are inherent in company law that we've identified come to fruition, we need to change the shareholder primacy social norm. And in the UK, there are probably two main changes that are needed. The first is a change to takeover regulation. We need to reduce the pressure on corporate directors to give them more discretion to take account of issues like sustainability, free from pressures to create short-term wealth. Both Beata and I have worked on takeover regulation, and this is a really serious obstacle. And the second change that I'd like to see is regulation of executive pay. The Commission in a green paper relatively recently even canvassed the idea that stock options might be prohibited altogether. Certainly, remunerating directors for increasing the share price even in the so-called long term, the five-year long term that we deal with. This should not be allowed. So we need serious reforms of executive pay. The cap on bonuses in financial institutions is totally economically justified, and given the externalities and social costs of corporate short-term profit maximization, we can also justify serious regulation of executive bonuses. So I hope that's inspiring. I hope these are exciting ideas, but being realistic, the EU is going to have to impose them on us. Okay, thank you.